Hi everyone!
Hi there!
Welcome to Winning Wednesday.
Yes, welcome to another edition of Winning Wednesday, brought to you by the attorneys at Adair Thurston. We're so excited to be here. I'm Gabriela Vega, the immigration associate at the law firm, and joining me today is our criminal defense attorney, or one of our criminal defense attorney extraordinaires, Brandon Cotts.
Hello again!
Brandon! We are so excited to talk to you today. We are doing a special normally out of sequence, but very fun topic today. We're going to be doing a criminal defense topic, inchoate crimes.
Yes, I'm so excited. Inchoate crimes, conspiracy, solicitation, attempt.
Yes.
Some of my favorite subjects because they can get a little bit wild.
Absolutely, absolutely. And in addition to talking to you guys about this great criminal defense information, we are doing a giveaway, right, Brandon?
Always!
Yes, in support of our community. Brandon, do you want to share a little bit about the giveaway and what you got to do to win?
Yes, so today we are going to be giving away, let me see
Super
if I can...
Saver cards!
Yay!
Super Saver cards.
So, if you've never seen these before, they are sold by, this is Manhattan Ogden Public Schools?
Correct. The USD 383 Foundation does a great job of getting a lot of area businesses to participate. You buy a card for $15 and there are hundreds of dollars worth of savings as part of these cards, and it goes to a good cause. It helps our children's public school system. So how do we win the card, Brandon?
We ask a question. It's that simple.
Yeah.
So,
That's right.
I was going to say.
Right. No. Yeah, that's exactly right. All you guys have to do to win one of our cards, valued at $15 each, is ask us a question about the topic that we are discussing today: inchoate crimes, attempts, conspiracy, and solicitation. And so, Brandon,
let's do it.
Let's get started.
Awesome.
So, Brandon, I think that one of the things that we found is that the best way to communicate with our friends is by starting with a good basis of definitions to provide them, right? Okay, so today I think we need to start with inchoate crimes. There's about 6 definitions that I think are really important here.
Okay.
Attempt, conspiracy, solicitation, general intent crimes, specific intent crimes, and mens rea.
Okay.
Do you feel like you're back in law school?
I do.
Where's your blue book?
Oh, man. You know, the coolest thing about law school is, if you're ever a young lawyer out there, in criminal law class, inchoate crimes is potentially going to be one of the most challenging things you do.
Absolutely.
And so if you're a law student, this is going to be great for you, maybe a little refresher course, but right. We're going to boil it way down quick and easy, right. Just for a little surface knowledge.
Absolutely. So what's the legal definition of attempt, of an attempted crime?
So for an attempt, a lot of these are going to be court definitions, but we're going to break them down. An attempt to commit a crime consists of 3 elements: the intent to commit the crime, an overt act towards the perpetration of the crime, and 3, a failure to consummate it. So in an attempt, the failure is the whole deal. So
okay. Second definition, conspiracy.
So a conspiracy is an agreement between two or more persons, and that's going to be important for us, to commit or assist in committing a crime, the commission by one or more of the co-conspirators of an overt act in furtherance of the conspiracy. And again, this is going to be like kind of odd language, but as we move through this, you're going to see that the thing that separates attempt, conspiracy, and solicitation is really how far we got.
Absolutely. And once we start getting into the other parts of this conversation, we will be giving you a lot of filler that will help you understand how these work together and why we as informed legal consumers should understand how we can either protect ourselves against these kinds of charges or how, there's a lot of ways that we can learn from this conversation. So.
Right.
Solicitation. What is the definition of solicitation?
So solicitation, different than conspiracy, can be one person, but basically with the solicitation, we have one person encouraging, threatening, or by some way trying to get another person to commit a crime.
Okay.
Right? Most commonly like soliciting a prostitute, right?
Okay.
So those are the heaviest definitions that we have today.
Absolutely. Now, lawyers, we like to split hairs about things, right? And so we have something called general intent crimes.
Right.
And we have something called specific intent crimes.
Right.
What are basic definitions of these, and how does that impact the overall picture that we'll be discussing today?
So the primary difference between a specific intent crime and a general intent crime is going to be the level of thought put into it, right? Most specific intent crimes are going to be things like intentional killing, right? I point a gun at somebody, I mean to kill them, and I do it, right?
So and again, we're not going to get too deep into this because we've got a lot of areas where we will cover this, but premeditated murder.
Right.
That's specific intent. I had to be like, I'm going to go buy a gun. I'm going to shoot someone. That kind of thing, right? Yeah.
Right.
Okay. And
general intent really is crimes in which we can commit without having that specific level of wanting to commit a crime, right?
We didn't set out to be bad, but something bad happened.
Right. And in the law in Kansas, we have a word that you'll find thrown around a lot called reckless, which is, you didn't set out to do something, but you ignored things that regular humans would, knowing that they could cause a danger to somebody else. And that was an extreme deviation of the standard of conduct for what a regular person would do, right?
Right.
So basically, you were reckless.
Right.
Okay.
Gotcha.
So those are going to be our main separators.
Absolutely. And of course, no legal definition process is complete without throwing in a little bit of Latin in there just to show everyone how smart lawyers are. What is mens rea? What does that mean?
Mens rea is guilty mind. In fact, I think this is on a Legally Blonde at one point.
Absolutely.
Right? Mens rea is the mental state required to commit a crime. Pretty much every crime that you're going to deal with is going to have some kind of what we call culpable mental state, right?
Okay.
What mental state did that person have to be in order to satisfy that crime? Specific intent, knowing, reckless, whatever.
Absolutely. Okay. So now, getting this basis, we want to move into our new section, our new segment that we like to call
Fact or Fiction!
Fact or Fiction.
So, before we start this, you should all know, Gabriella is a trivia whiz.
I am?
Yes. If you ever are on Jeopardy and you need a coach, she's the one you need. So, through these questions, we're going to ask fact or fiction, we're going to answer them, and maybe a couple surprises along the way.
Absolutely.
All right.
Okay, so this section will then help us feed into a discussion about how you as a lawyer can help people with these types of cases, right?
Right.
Okay, so fact or fiction, Brandon? It is possible to get out of a conspiracy once it has started.
Fact. You can.
Okay. Brandon, Fact or fiction? Mere preparation is enough for me to get in trouble for attempting. For attempt.
False. I mean fiction. Fiction.
Okay. Now, Brandon, how knowledgeable are you about the world? You drive a car?
Yes.
Okay.
Some days she works.
So, fact or fiction? Bugatti, Lamborghini, Audi, Porsche, and Ducati are all owned by Mercedes-Benz.
Fiction.
That's right, it is fiction. They're owned by Volkswagen.
Whoa, empire.
Like, some badass cars in that lot, right? Okay.
I'm surprised I got, well, I guess it's 50%, right?
Right. Okay, Brandon. Legal or factual impossibility is a defense to an attempt crime.
Fiction.
Okay. Brandon, next question. It is enough for me to plan the time, location, and manner of committing a crime for me to be involved in a conspiracy.
Also fiction.
Okay. Next non-legal fact or fiction.
Am I slaying it right now?
You are. You are. I think you have gotten every single question correct. So let's see how good you are. What do you know about the world, about the animal kingdom?
Oh, David Attenborough's my homeboy. I love my chances on this.
Okay. Fact or fiction? Giraffes have no vocal cords.
Fact.
That is a fact, yes.
I just was like, have I ever heard a giraffe make a sound?
Have you ever told the little kid, what does the giraffe say?
Nothing,
because there's no vocal cords.
It's much different than what the fox says.
Fact or fiction? Legal fact or fiction.
Okay.
I cannot get into trouble for conspiracy if I am acting alone.
Correct. But fact. Sorry.
Final legal fact or fiction. It is possible to be charged with attempt for a general intent crime.
That is fiction.
Okay. Final non-legal question.
Okay. Is this the last one?
This is the last one.
Okay. This is like almost a perfect score.
Is this a perfect score? Are you still the law school gunner that you were?
Yes.
Okay. Fact or fiction? Humans are born without kneecaps.
Fact.
That's right! 100%!
Well, friends, this has been Fact or Fiction.
That's right. Okay.
So now
let's get back down to business.
Okay,
Serious
so now
stuff.
we break it down.
Yes. So we talked about the fact that it is possible to get out of a conspiracy once it has started.
Right.
Talk a little bit about that to us. What is it? How does it happen? What is it called? How do you do it?
Okay, so one of the things we know about a conspiracy is it is an agreement between two or more parties, right?
Mm-hmm.
So one of the things we know about agreements is we can get out of them. So if right now you and I conspire to go rob a bank, right?
Okay. Which we would never do.
We would never do unless we were real hard out. No, I'm kidding.
No.
But what would happen is, for instance, we're going to rob this bank and we go buy bags to put all our money in. We go grab some guns, right? This is potentially mere preparation.
Correct.
But then we go to the bank. And then right when we get to the door, I say, oh, whoa, Gabriella, I don't know if we should do this. I'm getting butterflies in my tummy. I think I'm going to go home.
And I'm like, no, damn it, you go in there.
Right.
Okay.
So, actually, that's a really good hypo because that spins into solicitation. But back to that conspiracy, right? When I say I no longer want to participate in that conspiracy, we call that voluntary abandonment or withdrawal.
Okay.
And basically, as an agreement, I can also get out of it.
Okay.
And the law encourages us actually to abandon conspiracies, and in fact, abandonment of a conspiracy is an affirmative defense to the charge of conspiracy.
Okay. Now, understanding all of those pieces, how does someone who is at this moment charged with a conspiracy, help their attorney minimize the impact of the situation? What do you recommend that they do to help get the ball rolling with you?
Well, if you are charged with conspiracy, the first thing that you should do is talk to a lawyer, right? The fact of the matter is that with those cases, a lot of times evidence can look a little bit different.
Right.
Because actually, under the federal rules of evidence, we have this thing called an admission by a party opponent. And what that means is the statements of your co-conspirators can actually be used as proof in your case about this conspiracy, right?
Right.
So the issue with a lot of conspiracies is that people maybe start rolling over on each other,
Right.
testifying
Of
against
course.
one another. And once one canary sings, you can really get the whole cage going, right?
Absolutely.
So it's really important that you talk to an attorney early,
Before you try to explain things away.
Right.
You're never going to explain things away, and especially in something like a conspiracy crime, a lot of it is going to be he said, she said. So you really need to be able to give your attorney the most ammunition by saying the least amount of words.
Absolutely. Detective so-and-so wants to talk to me about whatever. I'm really sorry. I need to go talk to an attorney. And, most times they're going to tell you, don't do that, right?
Move forward from there with appropriate representation, of course.
Right.
Okay. Now, the second fact of fiction that we discussed was that mere preparation is not enough for somebody to get in trouble in an attempt, right?
Right.
So let's talk a little bit about attempt crimes. What is the purpose of charging someone with an attempt crime versus creating it or making it a different crime, a lesser crime altogether?
So some crimes, actually, with an attempt, we have that failure at committing that original crime.
Of course.
When in fact, in the law, sometimes we actually recognize that you can't have an attempt in certain kinds of crimes because they actually just turn into a different crime, right?
Gotcha.
Attempted murder where I miss and hit somebody else and kill them, that could just be reckless murder, right? Mm-hmm. So rather than being that attempt, it just transforms into something else. And likewise with attempts being a specific intent crime, they can also exclude certain crimes that can be charged.
Okay. And so in this area, do you guys look at the statutory possibilities that exist and try to find ways to minimize? I mean, is that one of the tools in your arsenal?
Yeah, and specifically with the inchoate crimes, right? We have specific intent crimes, period. So specific intent is the highest you can get that the prosecutor's going to have to prove against you.
Right.
So by getting an attorney involved, right, you're already saying to the prosecutor, hey, you charged the hardest crime you can possibly try and prove, right? But this could be something else.
Right.
Something easier and more provable to you. And maybe more beneficial to my client, right? Maybe less penalty.
Of course.
But that's all in the negotiation.
Of course. Okay, now we also talked about legal and factual impossibility.
Yes.
Why is this an important distinction in law?
Well, back in the common law, they're actually. Oh, do you like?
I liked it a lot.
I channeled my Blackstone.
I see. Yep.
Back in the common law, logically you can say, well, I could have never committed that crime. Therefore, I could have never attempted it. I could have never completed it, right? Factual or legal impossibility. And going through the cases that kind of surround these issues,
right.
One of the things that stick out most to me is, have you ever seen that show To Catch a Predator?
Yes, so like the Dateline NBC where they do the sting operation. Yeah, absolutely.
Right. And so, and then, at the end, the police come and tackle this dude.
Right.
But the fundamental part of that is, when they hire those actors to engage in those sting operations, right, there's not real children sitting behind those computers.
Thank goodness.
Yes, right?
Thank goodness.
Engaging in these stings where, they have to say things that maybe constitute a crime, right?
Right.
So the mere fact that you could not have solicited sex from a minor because the other person on that other side of the computer was an adult police officer, that doesn't matter, because as we talk about mens rea,
there's a specific intent.
Right, the culpable mental state. You had formed the intent to commit that crime, and you had attempted but failed. Right. So
you showed up to the house that Dateline NBC told you to show up.
And Brian Williams was sitting there waiting.
He's like, boy, girl, you got some splaining to do.
So that is why legal or factual impossibility is not necessarily a defense to an attempt crime.
Absolutely. And now, obviously, one of the great examples that you give is this idea of a sting operation where child predators are trying to uncover child predators, right? So in these types of cases, where does the concern about entrapment come into play? And is that a concern, or is that something that's just another arsenal in the tool, or another tool in the arsenal of the criminal defense lawyer?
That's it, right? So for entrapment, which I'm
so smart, I answered my question for
you
myself.
You are brilliant. So actually, I hadn't even thought to bring up entrapment today, but basically entrapment is where they give you the tools, the resources, and the suggestion to commit a crime. That is overreaching, and that is what we call entrapment. And entrapment is an affirmative defense, meaning one that a defense attorney would raise at your trial to say, you know what, they did commit a crime, but they were entrapped.
Right.
So we should be found not guilty.
Gotcha. Okay.
Right? And in this case, yes, if you have a conspiracy, an attempt, or a solicitation where it's manifested by like a sting operation, one of the first things that we're looking at is, how did you get in contact with the police? What did they say to you during this operation? What kind of things did they give you?
Right.
And so, yes, at that point, I mean, anytime you're raising an affirmative defense, like, you need an attorney. I promise you cannot raise an affirmative defense by yourself.
Absolutely.
Yeah.
And we also talked about the idea of people not being able to get into trouble for a conspiracy if they're acting alone.
Correct.
Right. And so let's talk a little bit more about that. Is there a history of these types of charges being made?
Like a acting alone conspiracy?
Yeah.
So it used to be, and in the law we have a term called multiplicity or duplicity, which is where charges are so similar that they become multiplicitous. And it's kind of the same as like me charging you twice for the same thing, right? You come in and buy a pair of shoes and I say, that's $29.99. Right. That's $29.99, right? In the same respect, it's like getting a double whammy. If I charge you with murder and conspiracy to commit murder, right? I'm just stacking two crimes on top of you. The law does not permit that, generally speaking. So in Kansas, we use something called the same elements test. And if a crime constitutes the same elements, it cannot be charged. That would be multiplicitous or duplicitous. Okay. And again, we really want an attorney to be looking at those charging documents and to be looking at what's actually there. Because, I mean, frankly, if you can find a multiplicitous or duplicitous charge, boom, right? Like we just knocked off one count.
Right. Absolutely. And in these types of cases, especially where you have government actors inciting, what level of access do you guys get to the discovery that's available, the tapes that have been, because they surely should be recording all these things, right?
Oh, yeah.
And so how does that play into what you guys can then do for your clients?
Well, I get access to basically everything. I will say that in my position where we are in terms of our jurisdictions, most prosecutors have an open file policy with us defense attorneys, meaning that they just turn over what they have, right?
Okay.
Not always are they required to do that, and sometimes that can cause us to engage in some battles about what we're entitled to and what we're not. But for the most part, prosecutors try and avoid those battles entirely because they take up time and they're kind of useless. So I have been very lucky to have prosecutors who generally just turn evidence over to me. That's important because it allows me to review in real completeness what is going to be presented against you. And that's important for us making an informed decision before trial. Because, if somebody hid the security video of us robbing the bank and, we thought, oh, nobody saw us. No, we had ski masks on. We're going to get away with this, right? And they don't turn it over. And then at trial, we see that video. That could be grounds for what we call mistrial.
Right.
And, like I said, luckily that's not something that I regularly come up against.
Right. Well, it always lucky to have good jurisdictions and where people are following the law.
Yeah.
Absolutely. Now, what, if anything, are the important pieces that an individual should know about getting themselves ready to defend these types of cases? Or what are some of the tips that you would have for individuals who are now in this position?
I love this. Okay. So
that's a question you were not expecting.
No,
so.
I love it. But one of the things that I tell people always is there's this old saying that the last person you want to be surprised is your attorney. I say, and that's absolutely correct, because number one, if you don't tell me everything, I'm going to show up and I'm going to look stupid. And what's worse is you're going to be paying me to look stupid. Okay?
Yes.
Now, as lawyers, we are sworn to secrecy. We have attorney-client privilege as well as Rule 1.6. So we cannot be compelled to tell people facts against you without a court order.
Correct.
And we are also not permitted to disclose facts that we learn through the course of our representation. Unless you waive those things, which we're not talking about that.
And most often we don't ask for that
absolutely,
kind of stuff. We
absolutely.
don't ask for waivers because we do want to protect individual rights.
Yeah, so you can go to confession, talk to your priest, you can talk to your lawyer, we're both going to keep a secret, right?
That's right.
But the fact of the matter is, if you're preparing to come talk to a defense attorney about a crime like this that you're charging, especially where maybe we've shared a lot of statements with co-conspirators, we've sent some text messages, whatever. Again, we do not want those to be surprises. That is something that we need to know about pretty quickly and pretty early on, because the fact of the matter is you just do not want that bald fact flying out in court. Right. And you also don't want to surprise your attorney. Give them a good opportunity to prepare your best defense. Don't blindside them. They're trying to help you.
Absolutely. Absolutely. So, Brandon, in closing, what are your thoughts about how we can best be prepared to go talk to attorneys about these cases? Like, what are the give me two things that somebody should have ready? I mean, obviously, if there is evidence out there, bring your texts, bring your mobile phones, bring everything that shows the pieces of the puzzle, right?
Right.
Okay. And what else?
I mean, really, I think that in the beginning stage of a case, that's really probably the most important thing, is bringing those pieces of evidence, right?
Okay.
And most of the time, my experience in these kinds of cases is that you're not going to have a lot on you. You're not going to have police reports. They're the detective statements.
Correct.
Like, those are going to come later. But absolutely bring those individual pieces of evidence that you have that can kind of help point an attorney in the right direction. Especially if they have to kind of get on the ground rolling right away.
Absolutely.
So
we're starting next month, March already coming up. Next month is March.
I'm so excited. Except for February, it's gone so fast.
So fast. And March, we are very excited. We're going to have some excellent programs. Week 1, we're going to be talking in preparation for Fake Patty's Day. We're going to be talking F&E, DUI, and MIP. Oh my! So we're going to be understanding fleeing and eluding, driving under the influence, and minors in possession. If you have young friends or young adult children, this would be a good program to encourage them to watch, because knowledge is power. We can avoid getting into trouble if we understand the rules. And so this is the program that really is geared to our young college-age students, our international people who will be coming in for Fake Patty's Day.
Oh my gosh, yes. If you plan in participating at all, please inform yourself before you go out there. I can tell you from representing a ton of Fake Patty's Days in my past,
Yes.
a lot of stupid mistakes can be avoided just by knowing what people are looking for.
Absolutely. Week 2, for the immigration section of our Winning Wednesday, we'll be talking about removal of conditions on lawful permanent residence. This is one of the areas that, of course, I love. I do a lot of family-based, marriage-based cases, and this is just a second part of that happy law that I always talk about doing. So
I'm actually really excited about that one too.
Absolutely. Week 3, Autumn Fox will be joining one of us for paternity cases and advanced child custody considerations. So that'll be a really good program for all of us that have, divided families, that have children with people that we're not in relationships with. This will be a good program for you. So. And then finally, week 4, we're excited to have Lisa Ward back. She'll be talking about an estate planning topic. And so we'll be so happy to see our dear friend Lisa, who's been busy with travels and family and some really exciting things that she's doing.
Yes. That's really it that I have. And I guess
Absolutely.
We were really happy that you all joined us today.
Thank you so much for joining us.
If you have questions about inchoate crimes, comment on this video and we'll try and get them answered.
Better yet, if you have questions about inchoate crimes, you should be calling one of the wonderful criminal defense lawyers at our law firm. 785-776-2000. Come visit us at 1600 Points Avenue next to the Manhattan Arts Center.
Yes.
And so we are always here to discuss questions in your cases and to see if we're the right fit for your legal needs.
And honestly, you can see what a nerd I am about it just sitting here. So just imagine what I'm like in my office. So that's all I've got.
Thank you so much for joining us again. We appreciate your time, and we'll see you guys next week.
Have a good evening.